Hi everybody, it's Ernest Berghof, broker and CEO at Berghof Realty, and today I have with me Lon Lazar, who is going to answer some of the most pressing questions that we have in real estate. Okay, it's a pressing question, it's important, it's urgent, and yet so many of us don't really understand the process. And what I'm talking about is the trust and estate. So, if we own a home, we all know, my gosh, I should have this home in a trust. Well, the problem is so many of us don't do it, and the reason, we don't have enough information to get started. So today, I have my good friend Lon, the best trust and estate attorney I know. He has done hundreds of trust and estates all over the state of California. He is an expert in his field, and today he has agreed graciously, thank you so much for your time, to come down and answer the 5 biggest questions that everyone has about a trust and estate. Thank you so much
Right on, Ernest.
for coming
Thanks
down.
for having me.
I appreciate it.
Yeah.
Excellent. So let's just dive right in.
Sure.
So the first question really that I know I had when I was getting my trust and estate done is, so what is the difference between a trust and a will?
So really what that has to do with is whether you're going to get involved with the probate court. If you have a will, your will has to be lodged with the Superior Court in the county where you die, and the terms of that will are overseen by a judge who's the probate court judge.
Okay.
And in probate court, the number one concern is to make sure that creditors get paid first, and then identifying the heirs and identifying the people that are named in the will to get the distribution of your property. And that whole process can be confusing, expensive, time consuming, and most importantly, it's public, right? So everything that happens in the probate court is a matter of public record. If you have a trust, basically the same situation, same beneficiaries, same distribution plan, but it's administered privately by your trustee. It's not subject to any sort of public oversight, and it's often a much more, trust administration is much more streamlined than having to go through probate. So that's really the main difference. It's privacy and streamlined, generally less expensive, less time consuming, and I feel like it's a cleaner way to make sure that your assets are distributed the way you want them to be.
Absolutely. So one of the, just to clarify that, let's say you don't have an estate and you just have a will, it goes to probate. How long is this process going to take before your beneficiaries can have the property?
Sure. It really depends on what county you're in. Every county's got a different sort of timeline for the probate court calendar, but as a general matter, when there's no muss, no fuss, nobody's fighting about anything, it can take 12 to 18 months.
Wow.
To get through the probate process.
So
if you have people who are fighting about stuff, it can go a lot longer. I mean, I have sat in a courtroom, and seen probate matters that are 5, 6, 10 years.
Wow. So what about a trust? How long does it take?
Trust, generally, depending, again, how complicated the estate is, what the, what's the nature of the distribution plan, but trust administration should be able, if everything is to be distributed, should be able to be wrapped up in 6 months.
Wow, excellent. So that's a big difference as far as being able to do that.
Yeah.
So one of the things that I know I struggled with when I was getting my trust put together is, who is going to be the trustee? I had 2 children. One had just turned 19. I had another one who was 17 at the time. That's how long it took me to do a trust. Don't wait that long.
Don't wait that long.
Don't wait that long. So then we had to really think about the trustee who was going to be able to do it and come up with a kind of a plan to do that. So what are some of the factors to help streamline that process?
Sure, I don't know who you chose to be your trustee. A lot of times people want their children or child to be the trustee, which, depending on your situation, maybe that's going to work. Sometimes people want their best friend to be the trustee, because that's someone that they know and that they love and they trust, and that, depending upon what that relationship is like and what that person's acumen is with regard to financial affairs and legal affairs, could be a good solution. One of the solutions that I ask people to really consider is to nominate a professional fiduciary. One of the things that can get really sticky with people when it's a family member, especially if one family member is chosen to be the trustee and there are other family members who are beneficiaries, just the nature of families is sometimes people get a little jealous, and there's kind of bickering that goes on back and forth, and it can be really stressful for the trustee. If you choose a professional fiduciary, you've got somebody who's a neutral third party, who's trained in a variety of confidentiality and fiduciary duties and responsibilities. A lot of times they have a background in accounting. Sometimes they'll have a background in real estate. So you've got a professional licensed person who understands fiduciary responsibility and is neutral to everyone, and they have to administer the trust for the benefit of the beneficiaries, and so they can't take sides, they can't treat anybody more favorably than anybody else.
Yeah.
So I increasingly advise people at least to consider using a professional fiduciary.
I think the benefits of a professional fiduciary, in our case, we thought that was a really good strategy to go down. But again, to kind of give a sense for it, that may not be the solution for everybody. But so what kind of workload is involved in being your trustee? Like, if you're asking your best friend to do it, like, what are you asking them to sign up for?
Well, and again, it really depends on how complicated the estate is. Do you have you have several pieces of real estate that you have to either continue to manage or to put them all on the market?
Right.
A great story, I did a trust for a good friend of mine. He named me his trustee, and neither one of us had any inkling that this was ever going to come to pass. But literally 6 months after I did his trust, he died suddenly.
Wow.
And this is a guy that owned 15 parcels of real property up in Chico.
Okay.
And so now all of a sudden I've got 15 properties hundreds of miles away from where I am.
Right.
And I have to figure out, what am I going to do with am I going to continue to be a landlord for the benefit of his beneficiaries, which were his kids? Or are we going to liquidate everything? And so that is an unusual, I think, example.
Right.
But depending on the nature of the estate, generally what the trustee is responsible for doing is identifying creditors and identifying what the assets are that are in the estate, and deciding how to manage what the creditors need with what the what the assets are comprised of, and how to distribute the remainder to the beneficiaries. So, I mean, again, it really, every family situation is unique, and it's hard to say for sure. Like I said, in the most sort of streamlined, simple case, it can be wrapped up in 6 months. My friend in Chico, now we're on about month, I think, 16 now.
Okay. Very
but
complicated.
We're down from 15. We're down to 4.
Yeah.
So we've already got rid of 11 properties.
Right.
Paid off a whole bunch of the creditors, and it's kind of coming to its conclusion. If this was being done in probate court, we'd still have at least a couple of years ahead of us.
Yeah. So there you go. So you're cutting it down at least in a third.
Yeah.
Yeah. So another question I get a lot: what's the difference between a revocable trust and an irrevocable trust?
So the difference between those two things is, when you create an irrevocable trust, you're actually taking the assets out of your estate and you're putting them into this entity, and you're giving the trustee the authority to manage those assets for the benefit of the beneficiaries.
Mhm.
You lose all control. You're taking whatever those assets you're using to fund into the irrevocable trust, and you're putting it into the entity, and the trustee has the fiduciary responsibility to manage those assets for the benefit of the beneficiaries.
Right.
But you're done. You can't change it. You can't change the beneficiaries. You can't change the asset mix. It's
Right.
all done. A living trust or a revocable trust is something where you put things into trust, you name the beneficiaries. As long as you're alive, you're the trustee.
Right.
And you can do whatever you want. You can change the beneficiaries, you can put more assets in, you can take assets out. It can be completely amendable for different kinds of terms and stuff. That's why they call it a living trust, because it's a living document that you retain the control of. And for the purposes of the estate tax exclusion, if you put stuff into an irrevocable trust, that is removed from your taxable estate.
Right.
So super high net worth individuals use irrevocable trusts to get their taxable estate under the exclusion, because the federal estate tax is 40%
Right.
of everything over the exclusion amount.
Right.
So that's really one of the good benefits of having a irrevocable trust. The vast majority of people are going to be fine with a living trust.
Right. Right. I was going to say, it would be nice to be in that where that comes into play, but for most of us, yeah, the living trust, which is what we have, and
Right.
are able to, make changes, do what needs to be done as we age and as our daughters age.
Yeah.
We're able to just kind of make changes and
Your life
take care of it.
evolves, your circumstances change, the needs of the various people that are involved change, and it's nice to be able to amend.
What about a trust as far as protecting you from creditors?
So again, if it's in an irrevocable trust, it's out of your estate, so all of those assets are protected from creditors of you.
Right.
If it's in a living trust, the protection is rather limited. So you're not protected at all from taxes from the IRS or the Franchise Tax Board. You're not protected if you're married. You're not protected from a divorce decree order. Your everyday average creditor has to wait until you get a distribution from the trust in order to attach those assets and satisfy their debt. So it protects the assets to the extent that you don't distribute them to yourself. A creditor in that situation can file what's called a charging order if they have a judgment, and so that anytime a distribution is going to be made, it has to be made to the creditor first. So the protection in a living trust is limited.
So it's really not designed to do that at all. It's really not designed to protect you. It's not like a corporation. It's not like an LLC where you're trying to isolate assets out.
Right.
It's more of a way of managing it through the inheritance.
Yeah, it's really it's a way of providing for your legacy distribution wishes to be handled in a way that's less expensive, less time consuming, and private, as opposed to going through probate.
Nice.
Yeah.
So, kind of last question. Let's wrap it up with the with the catch-all. What is the biggest mistake you see that people make when they're either setting up their trust or thinking about it? What's the biggest? What's the number one that you're like, oh my gosh, I can't believe I have to clean this thing up?
Well, the number one mistake that people make is that they pay somebody like me to create a trust for them, and then they don't put anything in it. They don't take their assets and fund them into the trust.
Right.
It's not rocket science, and you don't need to be an attorney to do this kind of thing. One of the things that I do that I think may set me apart from some other trust and estate planning attorneys is when there's real estate involved, I take the responsibility of funding the real estate into the trust. I create the grant deed that says, I, Ernest, and
Right.
going to take my house that's in my name and put it into my trust, I draft that grant deed and I go and record it with the county. So at least the house is in the trust. But people have all kinds of bank accounts. They have investment accounts. They have 401ks. They have insurance policies. They have all kinds of other things. They have Bitcoin or whatever, right? In order to make sure that those things are in the trust, you have to make sure that the title to those things are in the trust. So it's really just a matter of calling your broker up or sending a letter to the bank and saying, hey, I created a trust. I want my account to be in the name of the trust. And that's how people fail.
Yeah.
They don't take that step, and so then they die, and something is in the trust. The house may be in the trust, but maybe there's $1 million in Schwab that's not in the trust, and so it does involve going into probate court and filing a petition to confirm those assets in the trust. It's a headache. It's not as bad as not having a trust at all, but that's how many people fail.
And that is, I have heard that time and time again. That is probably the biggest thing, is making sure, and they do call it funding the trust, which is an interesting term, but making sure that whatever assets, and usually it's the bank accounts that get left behind, it's like getting those into the trust so that, inevitably when that trust is needed, because one thing we know about a trust is eventually it will be needed. It's not one of those things that you're like, well, I might never need this. It's like, no, you will absolutely need this at some point, hopefully very, very far in the future, but you will need it.
Right.
So you do need to make sure that everything is in place and do it. I've got one final question. So how often do you recommend somebody review their trust, or maybe even sit down with you and just go over the trust and see if everything's still in it? Does everything still apply?
It's a good idea to do it annually. Certainly, it's a good idea to do it anytime there's a change in the law. Anytime there's a change in your circumstances. I mean, if you buy a new house, maybe you sold the house that's in the trust and you bought a new place, definitely want to contact your attorney and make sure that that new house gets funded properly in the trust. Whenever there's a marriage or a birth or a death or something, like any kind of life-changing situation, big job change, maybe you take a new job and much of your compensation is going to be in stock warrants with the new company. You want to make sure that the stock warrants are going to be in the name of the trust. So it annually is a good idea. Definitely anytime there's a change in the law or a change in life circumstances.
Excellent. So I want to wrap that. Lon, thank you so much.
Absolutely.
I really appreciate you taking the time to explain this stuff. It can be daunting. I don't feel like it's difficult to understand, but the daunting fact is, where do I start and how do I begin? So what I want to do is recommend anyone, all of my clients, if you own a home and you do not have a trust, give me a call and I will get you in touch with Lon, because having that conversation to just understand how to get started is the hardest part. So I want to facilitate that and make that as easy as you can, because everyone needs a trust. It is just simply that simple. So if you do not have one, give me a call and I will give you a personal introduction to Lon, and we'll get you started down the path of, I like to think of it as, for me, it was one of the last steps, and it shouldn't have been, of adulting.
It's true. And I like to tell people, once you get this all in place, you're going to find you sleep better at night.
It's true. It was hanging over my head for many, many years too long. Excellent. Well, again, thank you so much, Lon. I really appreciate it.